Over the past year, much has been said about the death of Chevron and the broader shift in administrative law, but its practical implications, particularly for environmental law enforcement, are just beginning to unfold. With courts no longer deferring to agency interpretations of statutes, regulatory uncertainty may increase, and enforcement mechanisms may face new legal challenges. This panel will explore how Loper Bright and related decisions are reshaping the balance of power between agencies, courts, and regulated entities, and what that means for the future of environmental enforcement. To help us navigate these questions, we are pleased to welcome an outstanding panel of experts. To my far right, we have Mr. Jeff McCoy. He is a senior attorney at Pacific Legal Foundation. His practice focuses on separation of powers, private property rights, and environmental litigation. He has argued before the Supreme Court twice and has won 2 cases that have opened the doors for private property owner suits against the government. To my right, as well, we have Professor Sommer Engels. She is a clinical instructor at Harvard's Emmett Environmental Law and Policy Clinic. She has 6 years of environmental litigation experience at the DOJ and served as Deputy General Counsel to the White House Council on Environmental Quality early in the Biden administration. To my left is Ms. Melissa Scacchitti. She is an associate at Blank Rome. Her practice concentrates on energy, environmental, and mass tort matters. Melissa has experience counseling clients on environmental matters and litigation, including overseeing the remediation of contaminated properties around the country, negotiating and complying with state and federal environmental agencies and statutes, monitoring and adhering to regulatory requirements, coordinating site access for environmental testing, and evaluating environmental concerns during transactions. And of course, to my far left is Mr. David Uhlmann, who will also be joining this panel discussion. Before we delve into Loper Bright's implications for environmental law enforcement, we need to understand the actual holding. Even many people who know that Loper Bright overruled the Chevron doctrine don't really know what the Chevron doctrine was. Professor Engels, could you please briefly explain the Chevron doctrine, the precise holding in Loper Bright, and its implications for regulatory agencies?
Of course. I'd like to start by thanking Madison and the Journal and Professor Agard for having us here. I'm really pleased to be here. I should also say up front that I am not a professor at Harvard. I'm a mere clinical instructor. Don't want to steal any glory that might come with that title. But yes, I'm happy to talk about Chevron, and then I'll talk about Loper, its specific holding, and then the reasons articulated in support of that holding. So Chevron said that when an agency promulgates a regulation or undertakes another action carrying the force of law, its interpretation of statutory text is entitled to deference if, first, the statutory text at issue is truly ambiguous, and second, if the agency's interpretation is reasonable. And the logic was that ambiguous text is an implicit delegation of decision-making authority to the agency. Congress can't make decisions that implicate agency expertise when it's promulgating statutory schemes that are very complicated. And so it leaves gaps for the agency, and the message is, agency, you're going to help us fill in this gap or resolve this ambiguity. Loper overturned that doctrine. It held specifically that the APA requires courts to exercise their independent judgment in deciding whether an agency has acted within the bounds of its statutory authority. And a court cannot defer to agency interpretations just because the law is ambiguous. Why is that? The court said first that agencies are responsible only for fact-finding and policy-making, and that courts are responsible for saying what the law is. The court also said that the fundamental assumption underlying Chevron, the one I just articulated, that ambiguities in statutory text should be interpreted as implicit delegations to the agencies, and is unrealistic, and we simply can't assume that intent. To be sure, some ambiguities are unintentional, and agencies have no special expertise in interpreting statutory text. Court said ultimately it's up to courts to exercise their independent judgment when determining the meaning of a statutory provision. Now here the court didn't give up on agencies altogether. They said courts can give, quote, due respect to agency interpretations of statutory text, especially if the agency's interpretation is issued contemporaneously with the enactment of a statute or it's consistent over time. And the logic here is that longstanding government practices are informative. Note here, though, that inform is not the same as supersede. The court also said that sometimes the best reading of a statute is that Congress has authorized the agency to, quote, exercise a degree of discretion. And so here the view is that deference has been replaced by discretion. It explained in one paragraph that some have called the most important paragraph in Loper, that a statute may sort of allow this degree of discretion in three different ways. First, by being an express delegation to an agency to give meaning to a particular term. Second, if the statute empowers an agency to promulgate a rule that, quote, fills up the details of a particular statutory scheme. Or three, if a statute authorizes an agency to regulate subject to the limits imposed by a term or phrase, like appropriate or reasonable. So in those cases, those three categories that I just mentioned, it's up to the court to identify the bounds of that decision-making space left by Congress to the agency and to determine whether the agency has engaged in reasoned decision-making within those statutory boundaries. And I just mentioned this most important paragraph is surely important, but we're still sort of trying to figure out what those three categories look like in concept and how to proceed in the light of Loper.
Thank you. Over this past year, so much has been said in the media and otherwise about the death of Chevron and its potential impact on future regulations. But what significance did Chevron even have in enforcement actions brought by environmental agencies such as the EPA? Would anybody like to jump in?
I'm looking at Professor Uhlmann in hopes that he might say something.
Okay, I'm on the spot. A few quick thoughts, and I kind of previewed my thinking about Chevron in the enforcement context in my opening remarks. The reality is that EPA didn't, and in my view shouldn't, receive Chevron deference in the enforcement context. Obviously, you're not going to receive it at all anymore, but even the remaining deference that Sommer aptly noted may be present in the Loper Bright decision really shouldn't be applicable in the enforcement context for a few different reasons. I mean, first of all, just as a pure matter of due process and fair notice, if the government is enforcing a regulatory provision, the law needs to be clear, and there need to be clearly, this is students may remember this from criminal law, from discussion of the legality principle, the idea that the law is a known thing and that people or companies can conform their conduct to the requirements of the law. If the law is unclear or ambiguous, that's not possible. And so not just in the criminal context, but also in the civil and administrative context, we don't want EPA or any other federal agency getting to make up or decide what the law is. They don't deserve deference in that enforcement context. They can establish the rule, get deference or not. In the rulemaking process, once the rule is clearly established, then it can be enforced. But the deference has to happen at in the regulatory process, not in the enforcement process. So that's just as a matter of fundamental fairness and due process requirements. EPA never did get deference in the enforcement context. The other thing I'd say, now this is more a matter of how the agency and its partners at the Justice Department exercise enforcement discretion, and it's a corollary to what I just said, but if we're in vague or uncertain areas of the law, separate and apart from what the Constitution might require, it's just not fair for the government to bring enforcement actions. You don't try and establish the law, figure out what the law means in the context of enforcement. So, to be sure, We tried during my many years at the Justice Department to be creative. EPA is certainly actually even more creative. A really remarkable place. I think part of what pains me to see the current assault on the agency and the rest of the federal government is the extraordinary number of hugely talented people who have spent decades there and how committed they are to protecting communities across America from harmful pollution. Their creativity is a great source of strength. But it absolutely shouldn't be the case that we're taking flyers in the enforcement context. We enforce EPA, I guess I can't keep saying we, I'll get over it eventually. But EPA should be enforcing known legal principles in the enforcement context. No ifs, ands, or buts. To be sure, we take on new areas. There I go again with the we. To be sure, the agency should take on new areas, tackle new problems, be resourceful in how it utilizes the available enforcement tools. But what the law says, what the law means, shouldn't be made up in or determined in enforcement actions.
Yeah, and I'll just follow up a little bit on what Professor Uhlmann said, is that many of these environmental enforcement laws, Clean Water Act, Endangered Species Act, have both criminal and civil potential penalties, and Chevron was never awarded in the criminal context. And so as a matter of logic, you can't have an interpretation for a criminal case that is inconsistent or different from an interpretation in a civil case. And so that is part of the reason why in many of these enforcement statutes that there was no Chevron deference.
Loper Bright struck down judicial deference to agencies' statutory interpretation, but other forms of deference remain. At least for now, courts still defer to agency interpretations of their own regulations under what is known as our deference. Courts also typically defer to agencies' expertise, policy judgments, and factual findings. And they evaluate agency questions through the ABA's arbitrary and capricious review, which itself is quite deferential. Post-Loper Bright, will there be a push for courts to look harder at these other areas where agencies have long received deference?
Well, I think one of the ways that this is going to look at is I think of it, there's a major case in the 10th Circuit called Uhlmann, which under the APA actually applies the federal rules of appellate procedure to district court proceedings because it analogized that an APA proceeding is an appellate proceeding, even at the district court level, where you have your finding facts and conclusion of law at the administrative level, and then you appeal that to the district court. And so if you think of it as that, as an appellate decision, then what you see is, for Chevron, I mean, the standards of review on appeal are questions of law are reviewed de novo, but the findings of fact are depending on, but either clear error or some other very deferential standing to the finding of facts. And I think if that remains the view, which, as I said, it's very explicit in the 10th Circuit, but I think all of the circuits are very consistent in that view, you're not going to get a lot of pushback on deference to findings of fact, as an appellate court doesn't push back and defers to a district court's findings of fact. But on the conclusions of law, I think it is now more consistent post-Loper Bright. It's a de novo standard of review, just as an appellate court would.
Yeah, I mean, I guess the thing I think about, and I've seen developing in the case law both before Loper and after, is sort of a mixing of the standards. I think we take for granted the idea that it's very easy to distinguish between questions of law, questions of policy, questions of fact. But in reality, there are a number of questions of fact that seem to implicate statutory text and questions of policy that are also muddied. And you can see in the case law that there are efforts in cases challenging agency action where the agency will say, we're entitled to deference, this is an application of our technical expertise, and parties challenging the agency action will say, yeah, we see that, but ultimately this is a mixed question that implicates statutory text, and therefore the agency might be requesting sort of Baltimore Gas type heavy deference for a technical determination, but this is a determination that implicates statutory text and therefore is one that the court should be looking at with enhanced scrutiny. There's an article forthcoming in the George Mason Law Review by Emily Hammond that talks about some of these issues and how we should be looking at agency expertise post-Loper, and discusses an interesting case in the DC Circuit, Maine Lobstermen Association. I have to admit here that that was my case. But the agency there said, this is a technical determination. We're looking at scientific data, discussing the effects of vessel strikes and entanglements on right whales. We've made our best determination based on the information in front of us. And the lobstermen challenging the agency's biological opinion said, that may well be, but look in the Endangered Species Act, which requires the agency to look at the best available science. And the DC Circuit's opinion reflects an understanding that the agency's determination was not necessarily one driven purely by fact, but one that implicated statutory text as well. So I'm hopeful that the standards of review Jeff mentioned will apply, but I'm also interested to see how the case law is developing on this point.
Okay, thank you. And Melissa, corporations constantly assess regulatory risk, and Loper Bright offers some new opportunities to challenge regulations, but also new concerns about inconsistent court rulings. How has the corporate sector reacted to Loper Bright, and what legal strategies are you seeing emerging?
Yeah, there are a few. Thank you, Madison. And before I sort of get into it, I just want to say a quick thank you on behalf of Blank Rome, Villanova, and the Environmental Law Journal have a long-standing relationship, so we're very happy to be here with you today. There's definitely a heightened vigilance among corporations in response to the changes. And as Professor Uhlmann was referring to, as you would see in a criminal law context, somebody wants clarity about what exactly the statutes are saying, the regulations are saying, and it's obviously a very difficult time to provide that. So a lot of corporations are conducting audits, looking into their permits to make sure everything is properly submitted, filled out, submitted on time, because as things change, they don't want to run into any bumps or hiccups along the road. With those audits, it requires, businesses taking a deeper look at their employees' understanding of whatever the changes might be. So these businesses we have looking at instituting sort of risk management or mitigation plans to sort of prepare for the event that something's going to come up, checking in to see that everything is in compliance, developing sort of internal policies and initiatives, disseminating those around the companies, training employees on that. But we're also seeing that there is an increase in cooperation between companies and agencies, making it clear that they're going to do what they can to stay in compliance, if they fall out of compliance, to get back into it. But I think that because we're all sort of learning how things are going to play out at the same rate, there's likely to grow, I think, a higher risk of tolerance when it comes to challenging certain enforcement actions or being more aggressive in litigation when presented with any sort of compliance issues. So companies are really starting to look forward as much as possible to just have a plan in effect for when things start changing, so there's not a lag in sort of responding to it.
Okay, would anybody else like to jump in and add anything?
I'll bite on the last thing Melissa said, because before I became the chief of the environmental crime section and had a midlife crisis and moved with my wife to and younger daughter to the Midwest for 15 years. We're East Coasters. We needed to be back home. But before all that, I tried a number of environmental crimes cases at the Justice Department, and I got to say, I always thought the companies were pretty damn aggressive throughout. So I'm wondering what this newfound aggressiveness is going to look like. But I do want to. I'll just, since I have the mic, I just want to pull back and make 3 quick observations that might provide context, particularly for students, that could be helpful. One is just an historical footnote, which is Chevron, everybody knows it is Chevron, but it's NRDC, Natural Resources Defense Council versus Chevron. And not everybody realizes that the Chevron case was brought by one of the nation's leading environmental groups, trying to keep a Reagan administration interpretation of a statute that they thought was not sufficiently environmentally protective from carrying the day. And the Supreme Court went with the Reagan administration. It's actually an anti-environmental decision, at least in its first instance. Now, over the years, it became quite a bulwark, if you will, for robust regulation under the environmental laws. But even there, I think there's an historical context that's worth noting, which is we did a tremendous amount of environmental lawmaking in the United States in the 1970s and into the 1980s. And by the way, I talked this morning about rediscovering bipartisan support for environmental protection. If you don't already know this, it's important to know that there was enormous bipartisan support for the Clean Air Act, the Clean Water Act, the Superfund law. I mean, the environmental statutes passed in the 1970s with margins you couldn't secure in Congress today to name a federal building. It's 88 to 7. 300 to 46. I mean, these were enormously bipartisan laws. And then it all stopped. Like we had an environmental moment in the 70s and 80s. By the Clean Air Act amendments of 1990, it was largely done. We've done one major update of the environmental law since then, the Lautenberg amendments to the Toxic Substances and Control Act. In the last decade, but really we stopped making new environmental law. And so I think there's a degree to which Chevron became important because it allowed EPA and in other contexts allowed other agencies to adapt to the changes that were happening in society and the new challenges that emerged. And they're basically using old statutes to address new problems, and deference became important in that context. And so I think when people mourn, in my part of the world, the government part of the world, maybe the NGO part of the world, when people mourn Chevron's demise, they're mourning the loss of those statutory interpretations as a way of trying to adapt 1970s, 1980s environmental laws to 21st century problems, the kind of problems I was talking about this morning. And I think I do think it's a challenge in that context. And then the one last thing I'll say, because it also ties back to what I said earlier, is, I do think the other subtext to Loper Bright is an end to the idea that we place stock in expertise. It's really about a surge in importance of the judiciary. The judiciary, and by the way, lawyers, we are the consummate generalists. We aren't experts in anything except the law. But the Supreme Court is saying, we're the lawyers here. We'll decide what the law means, and never mind all your expertise in the administrative agencies. And they get to decide. They have decided that's the law. We're going to follow it. But I do mourn a little bit the loss of respect for professional expertise. I do think that is, there's some role for that. So that's just another thing to think about as we think about what does all this mean and why should we care? I think it's another way. I mean, I just, call me a career public servant. I was one for 17 years before I became a law professor and then a political appointee. My heart is very much that of a career public servant. But, I believe in that work. I believe in what people do on behalf of the work people do on behalf of their country. And I believe it's entitled to respect. And I don't know that, I think we're a long way from that. I think it's just another example of that. And I mourn that a little bit. Sorry to be on my soapbox. I'm done.
I will say, I know Professor Alderman took a little bit of a cynical view. I'll take a different sort of cynical view. I think in some cases, the lack of new environmental laws was a result of Chevron because Congress people don't want to cause a storm. And so it was much easier to just say, let the administrative agencies pass these laws, then I don't get flack for it. And now we'll see whether Congress, and I know that, I mean, Congress has been very divided, but I look at examples outside of the environmental enforcement context, but in May, the FAA passed a in May, the FAA passed a regulation that required refunds for certain canceled flights, which I think under Loper Bright probably would not have held up. But Congress, a week later, passed a law that codified that, and now it is the law. And now if you have a canceled flight, you can, under certain circumstances, can get a refund. So I think it remains to be seen whether there will be new environmental laws. I think a part of it is that there is sometimes a reluctance to actually pass laws in Congress. But hopefully, and especially as you said, there has been bipartisan support. I mean, there was even bipartisan support for the NEPA reforms in 2023. So I think there may be, and I think we'll see, especially when courts start interpreting laws that are going to be the law of the land, whether Congress says, no, that's not what we meant, or that's not what we like, and whether there'll be some pushback for that. So we'll see. I take like I said, both a cynical and a positive view of that, and hopefully there will be some more forcing bipartisanship as a result of that. You know, Congress, this is your job.
All right, back to you, Jeff. The Pacific Legal Foundation consistently challenges what it sees as regulatory overreach, particularly in cases involving property rights and environmental permitting. Many property rights advocates view Loper Bright as a positive development that shifts power away from agencies and back into the judicial branch. From your perspective, how have those who challenge environmental regulations, particularly those in the property rights space, reacted to the decision, and what legal strategies do you see emerging?
Yeah, well, as what's been said, it remains to be seen exactly how this is all going to play out. I think in terms of strategies for me or similar organizations, or on those who represent small private property owners, I don't think that the strategy has changed that much, because it was always trying to make a very robust Chevron step one argument, and that's not going to change now, because it was always, here's a full statutory analysis, and different courts applied Chevron step one differently. I think that was part of, especially the argument at Loper Bright that this came up, how robust that Chevron step one was. But in terms of how this is going to play out, I think we're seeing the first, there was about, I think, a dozen cases, including some that my colleagues brought up, that the Supreme Court in a one-sentence opinion vacated and remanded because the lower courts had relied on Chevron deference to reach their decisions. And so there's been briefing in these cases, and there should be opinions very soon. And I think that's going to set the stage for how these challenges are going to play out going forward, and some of the questions of what do you do if there's mixed questions of law and fact, questions of, as Loper Bright said, express delegations to the agency are still going to be awarded deference. And I guess one of the questions is, what is an express delegation? Because every statute includes boilerplate language that the agency can pass all needful regulations. But the specific examples, I think it's in footnote 5 of Loper Bright, were very much defined this term, and it was very clear. It wasn't just a broad, it was, this is a specific term, agency, that we want you to define. And so I think we'll see playing out not only in these cases that were remanded by the Supreme Court, but in future cases, exactly how much deference and how courts are going to be interpreting statutes, and what parts of those statutes have explicit delegations of authority.
Would anybody else like to comment on that? No? Okay. So Sommer, you work with a law school clinic, and these groups often work on the front lines of regulatory and enforcement challenges, much like nonprofit advocacy groups. Professor Engels, from your perspective, how does the Loper Bright decision affect the ability of public interest organizations to navigate, challenge, or rely on agency regulations in their environmental work?
Thanks for the question. So I'm going to talk a little bit about the approach in litigation, the approach in rulemaking generally, and then specifically about our work in the clinic. And in terms of litigation, actually, Jeff and I agree a lot here. Before working at Harvard, I worked in the appellate section of the Environment Division at DOJ for 6 years. And we actually didn't make hearty Chevron arguments and tried to avoid Chevron where we could. As Professor Uhlmann has noted, we've known for a long time that Chevron was on life support. So the sorts of arguments we made there were, here's the prong one analysis, statutory tools of construction, counsel in favor of coming to an interpretation that's consistent with what the agency has done here. You don't really need to get to step two, but if you have to get there, you can defer. Now, post-Loper, I think the argument is very much the same, except that you won't be getting to step two. You say, here are all the tools of statutory interpretation, and here's why they support what the agency did. This is why the agency's action was consistent. Ultimately, the Supreme Court hadn't relied on Chevron since 2016. So although it was making some progress in the district courts and a little bit less in the courts of appeal, the fact that it's now gone may be more of a representative change and less one that has to do with development of the case law or particular strategies employed in litigation in support of agency regulations. I guess the thing that I'm most concerned about at this point is that signaling function and the degree to which it might affect forum shopping. There's an article coming out from Cass Sunstein that explains that pre-Loper, judges who might have been disinclined to agree with the agency might have seen the existence of Chevron as sort of a yellow light. Proceed with caution, interpret the statute very carefully. And now without Chevron, perhaps there's a green light to say, employ all the tools of statutory interpretation and arrive at the interpretation that seems consistent with the result you want to achieve. So I think that if that is true, and that the signaling function is to create a more muscular judiciary to sort of give a green light to statutory interpretation that may not accord with the agency's views, then that might facilitate some forum shopping that we might see play out in the courts. As far as the approach during rulemaking, obviously this is for the agency to mark out in the end, but we can already see a lot more time being spent in preambles for regulations explaining the scope of the agency's authority and why the action it intends to take is consistent with the statutory text. I think we're also going to see additional references to past practices and the longevity of the agency's interpretation of the statute or the particular policy that it's employing. As I mentioned, Loper recognizes that the longevity of an agency's interpretation can counsel in favor of giving the agency's interpretation of the statute at least some weight in the analysis. And I think, as we've mentioned, Loper recognizes that agency fact-finding is entitled to deference still, so we can see references to scientific judgment and factual analysis over policy or questions that might implicate statutory construction playing an important role here. And here again, as we mentioned, there are these three carve-outs for agency discretion that the court mentioned in that very important paragraph. So there might be additional text and regulatory preambles nodding towards at least one, if not all three of those carve-outs. In terms of my work, specifically at the clinic, we're not currently involved in active litigation as a party, although we have been active in filing amicus briefs in support of agency regulations under the Biden administration. And the argument we try to make in these briefs is to support the sorts of points that I've just made above about what text we might see in a regulatory preamble. So would say the agency's factual determinations were sound, the agency's policy judgments were reasonable, and the agency's approach is consistent with longstanding practice. But here again, as I mentioned, and as we've all agreed, there is still quite a bit to shake out after Loper. And so I think this is one more point where we want to pay close attention to development in the law.
Thank you, Sommer. Critics of the Biden administration argued that agencies were too aggressive in regulating, while President Trump is pushing agencies to act aggressively in the opposite direction, towards deregulation. How does the changing law of judicial deference relate to the flip from regulation to deregulation? One way of asking this more directly is, will Loper Bright help or hurt the Trump deregulatory agenda?
Well, I think in the context of notice and comment rulemaking, their agencies, to the extent that they're interpreting the law in a deregulatory way, are not going to get deference to that interpretation. And so I think you see some NGOs, environmental groups that have already filed or planning to file in anticipation of some deregulatory regulations, and will probably make very robust statutory arguments in that case, and that no, you don't get deference. This isn't a policy judgment. This is the statute that Congress laid out. I think there may be cases. Professor Alderman thinks that there may be cases where there are new issues, but I think that can, in some cases, many of these environmental laws are robust in many ways, and if you were taking, you can take a strong statutory argument that there are certain requirements that the agency must do. So again, as we're lawyers, so we always say it depends, and so that's kind of how a lot of our answers are going. Is that we'll see how it plays out, but it doesn't. I don't think the Chevron deference, and as we mentioned, Chevron itself was pro-industry, and so I don't think that Chevron deference is necessarily going to be anti-regulatory or pro-regulatory. It's going to be depending on the situation.
So I agree with Jeff. I think Jeff and I have agreed on everything this morning, and I don't know that everybody realizes that we're not supposed to be agreeing.
Pacific Legal Foundation, I think, sued you. So
yeah, many times. I'll see you outside.
Yeah.
But yeah, what's good for the goose is good for the gander, right? I just think any administration wanting to take a particularly assertive view of what statutory authority it has is going to have a harder time, and it doesn't matter whether that's a assertive position about what the statute means that's designed to do more regulation or less regulation. So, a lot of the work of clinics like Sommer's, of citizen suits under the environmental laws, some of it's, or a fair amount of it, is what's called agency forcing litigation, where the agency has a statutory duty to do X, and it's failing to do, has a statutory duty to regulate PFAS. I'm making it up, but right, whatever it is, and they're failing to do it, and a deregulatory administration is going to have to defend its refusal to regulate, not based on deference to their interpretation of the statute, but based on the plain language of the statute. So it runs both ways. I do think for challengers to government action, whether it's a challenge to government regulation or a challenge to government deregulation, I think they're arguably on stronger ground. Although again, as Sommer made clear, I think really well, Chevron, every case was Chevron step one. For people who didn't take administrative law or didn't cover this in leg reg, if you have that here, I don't know if you have that here, but Chevron step one, if the meaning of the statute is clear, where courts are required to give the statute the meaning Congress intended. And If step two is if the meaning's unclear, then they're required to give deference, or were required to give deference to the reasonable interpretation of the agency. Well, most cases, the judges basically decided, I mean, the statute was clear in whatever way the judge wanted the case to come out. I mean, it was gone so long ago that I don't feel like it has that much impact. And surely whatever impact it has, as Jeff suggests, runs in both directions. I think that is clearly the case. I will offer, though, that, this decision is not in a vacuum. So even if we're all saying Chevron was on pretty wobbly legs and wasn't a particularly vibrant doctrine by the time the Supreme Court overturned it, it's not insignificant that the court overturned the most often cited, actually, I think it's the most often cited case ever. It's certainly the most often cited case in the environmental and administrative law context. So they overturned that just a year or two, I'm losing track of time, after they, in West Virginia versus EPA, announced the major questions doctrine. And if you know what it means, like write your law review article now, because nobody else knows what, I mean, we're, someday we'll know what's a major question, but I think that's kind of like Chevron step one. It's like whatever the court wants it to be. However the court wants to come out, it's a major question if they want to strike something down. But you put those together, and then you add, we haven't talked about corner posts yet, but you add corner post, where the statute of limitations, which used to be pretty finite, is suddenly the most expansive thing ever. Your claim could just be starting to run tomorrow if you didn't exist until, if you create a new business tomorrow, even for a regulation that was enacted 30 years ago. Like, that's just, by the way, that's just crazy. But that's what they said. So you add all these things up, and you have a court that we might say seems a little hostile to environmental protection and other government function. And that, to me, is the bigger story around Loper Bright.
I had one point, which was just that completely agree that the Loper decision cuts both ways, but one feature motivating the court's concern about Chevron was the idea that with the existence of Chevron, agencies could flip-flop from administration to administration their interpretation of the statutory text. And so if in the Trump administration, the administration suddenly takes a deregulatory interpretation of a statute that it has long interpreted to require regulation, that could be something that counsels, that sort of cuts against its analysis, even if the substance of Loper itself doesn't play a substantial role.
Yeah, I mean, I think that's one, the flip-flopping, and especially, I mean, Brand X was the specific case that was also overturned in Loper Bright that said, no, you defer to an agency's interpretation, even if it's the exact opposite interpretation that was 4 years ago. And so I do think, and I usually represent individuals. I do represent individuals or small businesses rather than corporations, but, and maybe get some perspective on this, but for my clients, it does seem like there's going to be at least more certainty, and that is an advantage because once the court interprets the law, that's what it's going to be until Congress changes it. And so there's not going to be, there's going to obviously be, I think, some marginal changes. It's not all, but I think there is going to be more certainty. And I don't know if your clients are saying the same thing for larger organizations.
Yeah, I agree. I think that it's definitely going to give our clients more leverage in the respect of there being like a clear judicial determination on the whatever statutory language that they're litigating or challenging. So I definitely think because, the reasonable interpretation, the permissible interpretation that Chevron discussed, now having switched under Loper Bright to the best interpretation, I do think it's going to level out the playing field a lot more.
Okay. So the premise behind Chevron deference was that courts should rely on the expertise of agency professionals when interpreting ambiguous statutes. But with the demise of Chevron and the Trump administration's efforts to trim down the federal government, reduce the power of unelected bureaucrats, and lay off or push out large numbers of career civil servants, the role of agency expertise in shaping policy is increasingly uncertain. Will losses in agency expertise specifically affect judicial deference to agencies?
Well, I think one thing is to remember, we do have a system of federalism in this country, and there are still states, and I assume many states that are going to take very strong environmental stances within their states. And so I do think there may be a lot more litigation on a state level coming forward based on environmental laws for there. And states have different levels of deference to their agencies. One of my colleagues did an analysis, which is now outdated, but about Chevron-like deference in various states. And some states are passing laws to get rid of that. Others have never really afforded Chevron deference, but kind of a Skidmore-like deference, and some have a very strong Chevron deference. So I think that's another playing field to remember when we're talking about environmental enforcement, is that it's not all at the federal level. There are still robust state laws and I think that is, with how the Trump administration's playing out, I think there's going to be a lot more litigation on the state level. And since we are in a law school, I always hear from state court judges, don't forget state Supreme Court clerkships. Those are just as good. And I do think that there's probably going to be a lot more litigation on the state level going forward.
When I think about personnel cuts, I think about declining expertise in the technical sort of substantive sense. And although I have previously expressed concern that courts will be less eager to defer to agencies' technical factual findings, or that litigants will queue up these questions in terms that sound in statute, I remain optimistic that agencies will still be getting at least some deference for their technical expertise, even though the Trump administration may be culling career civil servants from their ranks, in part because when we talk about deference in this capacity, sort of the classic, what I've mentioned, Baltimore Gas and Electric, we're talking about relative deference. And as Professor Uhlmann mentioned, judges, attorneys know nothing but the law. So I'm hopeful that no matter what happens to the agencies, courts will continue to recognize that between judges and agencies, the agencies will always have more technical expertise.
Let me add two thoughts. One is on the culling of the federal government is is a term that's been used, and and look, there may be people, maybe lots of people who think, hey, the idea of cutting the size of the federal government, limiting the size of the federal bureaucracy, like that sounds good. As soon as you say bureaucracy, like who doesn't want to limit bureaucracy? Who's in favor of lots of bureaucracy? So I don't object to the idea that the new administration wants to take a hard look at the government and decide how it can be more effective and even more efficient. By the way, this is every other incoming president wants to do this. Ronald Reagan did this. Bill Clinton did this. Now Donald Trump is doing this. It's a perfectly appropriate review function, and I think healthy for government to. It's obviously not every administration, but every periodically to have a process of making sure government's working best for the people. That's what government is supposed to do. It is public service. What I object to, and what I object to in the strongest possible terms, is first of all the fact that it is so much of an attack on individuals, on the people who serve in the federal government, and so destructive of their careers, and for many of them, their lives. And there seems to be no regard for that. But even if that doesn't matter, because it's just, a cost of doing business, a cost of reducing government, how about taking a hard look How about actually spending a few weeks, maybe even a few months, reviewing government operations and figuring out which ones are beneficial to the American public, which ones should be maintained, and hopefully, if your assumptions that the government is too big are right, figuring out which ones aren't working for the American people. Do your homework, for crying out loud. This is just reckless, it is irresponsible, and it is destructive, not just for people, but for programs that protect all of us. And maybe I should just stop there, but I just, when we talk about, what's happening with the government and the loss of expertise, I mean, keep it in context. This is being done all wrong. Whatever should be being done is not being done. And this is hugely harmful. Now, I do agree that the ping-ponging back and forth between, just to come back to the law, of the ping-ponging back and forth is not a good thing. And from an enforcement, companies would prefer it not to happen. From an enforcement standpoint, I'm thrilled. Clear rules are what enforcement needs to be effective. And I think Jeff's right about states. States have ours is a federal system. States have a huge role to play. And I think we need to look to states to fill the gaps that the federal government is inevitably going to leave to us, given if what's happened over the last few weeks continues. But I do want to caution that A, states don't have nearly the resources the federal government does, and B, all states are not created equal. So whether you have strong environmental protections in a country where the federal government exits stage right is going to depend on what state you live in. And we tried that once. We tried that in the decades before the 1970s. And we had rivers on fire. We had unbreathable air. We had hazardous waste sites all across the country. So absolutely states are important. States play a vital role. States can't do it all by themselves, and not all states are equally committed. So I just think we need to keep that in context.
So now we'll get to Jarkissi, corner post, and the major questions doctrine. What happened in Jarkissi, and could we see a shift toward more judicial enforcement actions? Or should we be looking collectively and individually at Loper Bright, Jarkissi, corner post, and these major questions doctrine cases?
Well, I'll start with my perspective on Jarkissi, and I think for a lot of these, as we discussed, a lot of these criminal or environmental enforcement statutes have criminal and civil on it. And if you bring a criminal enforcement, you're entitled to a jury. And so I think, I don't know all of what goes into deciding when to bring a criminal, when to bring a civil. And I don't know if this is going to affect that aspect of it, because if you're going to get a jury either way, then you may the enforcement agencies may just bring a criminal case anyway. But I think in that case it does, and in some of these environmental statutes, I know in the Clean Water Act, at least at the penalty stage, there was always a right to a jury trial. So I think in some aspects there may not be a lot of movement. But I do think, like I said, I think if you have a criminal and a civil enforcement, I think as a matter of due process and fairness, it shouldn't necessarily be the enforcement agency that decides whether or not you get a jury. But that you should get a jury, and if it's going to be a similar case, that you can bring criminal or civil. And we'll see how the agencies play that out and whether they do bring more criminal enforcement. But I think from that perspective, that's I think that was beneficial in that respect, because now we'll see, as Professor said in his talk, there may be some distinguishing factors on whether or not the Seventh Amendment applies to these environmental statutes. But if it does, then I think it will be more certain that regulated parties have a right to a jury trial if there's going to be an enforcement action.
All right, maybe we disagree finally. I mean, first of all, I mean, criminal enforcement, it should never be the case that the government's deciding whether to do a case criminally turns on the availability of a jury trial. I mean, criminal enforcement should be reserved for the most egregious violations, and I've written a lot about, as a law professor, about the fact that there should be not just the ability to prove the case beyond a reasonable doubt, although surely that should be present, but that there should be some aggravating factor, some reason that makes the case criminal. Like, why is this a criminal case? Maybe it's the harm that resulted. Maybe it's the fact, actually most often, it's the fact that there was false statements or other kind of deceptive or misleading conduct that accompanied the violation. Maybe it's a violation that just was occurring over and over again, so that the repetitiveness is what makes it worse. Or maybe it's a company that just totally operated outside the regulatory scheme that companies spend a lot of money participating in. That should be how we decide that a case should be criminal. Surely a case like Jarkissi shouldn't lead to a surge in criminal enforcement. I'd be concerned if that were the case. So I actually think the Jarkissi question, and I guess Jeff and I aren't really disagreeing that much. He's raising a question, and I'm saying I don't think that should change things much. But what I think the question that Jarkissi raises, if it's extended into the environmental context, and that remains to be seen, but if it's extended into the environmental context, you know, there are a lot of big cases, civil cases in the environmental context. They already are jury cases, and appropriately so. No quarrel there. But there are a lot of smaller cases in the environmental context. A lot of the 1,850 administrative cases that I referenced from the last year alone are so small, I never heard about them as assistant administrator. Like, that would be, I mean, they didn't even get to Washington. They were cases, you know, the Toxic Substances and Control Act says that if you are a landlord in a building that was constructed before 1978, you have to tell your tenants that there may be lead paint in the building. Pretty straightforward public health requirement. Lead poisoning remains a really big problem for children. Lead poisoning happens actually a lot in poorer communities where buildings are older and where they may not be as well maintained. Those residents are entitled to know that there may be lead in the building. You fail to do that, there's no delegation to the states. So the states can't do, TSCA is only federal. So for that program to be implemented successfully, EPA enforces it. The penalty might be $500, $1,000. Jury trial? Really? Like, are we going to flood the federal court system with those cases? I can keep going. There are other examples of this, but there are lots of different ways that the laws are broken. And just as we have traffic court for some violations that, you know, people encounter, hopefully not, but occasionally in their lives, like, you know, having some kind of administrative tribunal, I think just makes logical sense. And I don't think we have the resources in our judiciary to take on all those 1,800 cases, nor are they the kinds of matters that should be in federal district court. They're going to be crowding out a whole bunch of other cases that actually are better suited to federal court, in my view.
Well, I think maybe one of the issues is how the Seventh Amendment is written. I forgot that it's like $100 so, I mean, it's hard to amend the Constitution. That may be the very problem because, I mean, like you said, yeah, with traffic tickets, but I mean, for most misdemeanors, you still get a jury trial, and I think, and there are many criminal cases, and everybody has a right to a jury trial in that, and there are still, I mean, plea bargains and ways to get that don't log up the system. But also, I mean, if you're, for a case like that, I mean, that's going to take an hour for a jury as well. And yeah, it is inconvenient, but I think in some respects, maybe there is a way to get an amount that is more attuned, as you said, to a traffic ticket. That may just be part of the problem with the Seventh Amendment setting a specific amount, a dollar amount, which I think also raises an interesting question of what does that dollar amount mean? Because $100 in the 1780s was a lot different than $100 today.
All right, this wraps up our discussion of Loper Bright and its impacts on environmental enforcement actions. So I'd like to thank each of our panelists for taking the time to travel out here to speak with us and share your insights.